Good afternoon, everybody. This is Immigration Attorney Irene Weisman. Today is Monday, January 5th, 2026. Happy New Year, everybody. So I wanted to do this in December. Just didn't have a chance. I ended the year with a big trial, and then I, took about 10 days off. Okay, just much needed break. So what I want to do is I'm still gonna do this fast, okay? I'm not gonna take too much of your time, but I wanted to do a 2025 recap because a lot has happened. Probably won't be able to hit everything, but I'm gonna try to capture the major changes in immigration law for the year 2025, okay? So we had a change in administration, changes in the law, huge changes. It impacted immigration law probably the most. We had a congressional act. We had the Laken Riley Act that was enacted in the beginning of the year. What it does, it expands mandatory detention. What is mandatory detention? Mandatory detention is when a non-citizen gets detained by ICE, Immigration and Customs Enforcement. There could be bond proceedings, right, that would allow that person to come out on bond, but mandatory detention means that that person is not eligible to come out on bond, okay? And so basically, the Laken Riley Act, it expands mandatory detention for non-citizens who have been charged with various offenses, including theft and assault, okay? And this is just not a conviction. This also includes a charge, okay? So just, be mindful of that, okay? Not just a conviction now. This is just if you've only been even charged for that, okay? So just try to stay out of trouble, Everybody should stay out of trouble. I'm not going to lecture you on this one, but if you are, non-citizen, really try to behave, okay? Then we had, in July, we had the big beautiful bill that had a big impact on immigration law as well. And what it did was it increased the government fees for many things. It created the initial and then the annual asylum fee. We've never had a fee for asylum. Now there is a fee for asylum for administrative cases and defensive cases. It also increased significantly legal filing fees in immigration courts. So if you want to appeal the case, to the Board of Immigration Appeals, if you want to submit a motion to reopen your immigration court case, the fees are now significantly higher. It also increased other USCIS fees, and now certain fees are subject to inflation cost as well. So on January 1st, some of those fees have gone up, okay? So always check the USCIS filing fees and check the address before you file anything, because that tends to change frequently as well, okay? So we have those two big congressional laws, okay? Well, another thing that the big beautiful bill did, it really significantly increased the authority of ICE, really, because it gave them so much more money. It really increased the enforcement priorities, and by giving them a huge amount of funding, basically. So those two were congressional enactments. Then we have a lot of policy changes that happened, and then we had a lot of executive actions, right? So through executive action, we have increased authority for expedited removal. What is expedited removal? Some cases, some people that get caught by ICE are placed in removal proceedings and go and face a judge and go through the court process, right? The due process, right? When you go through court and apply for relief in immigration court. Expedited removal says there's going to be none of that. You're not going to go in before a judge and seek relief in immigration court. You're just going to be removed from the United States. So we have a huge amount of executive action that increased the expedited removal process. And then through the Board of Immigration Appeals, through case law, we have a great expansion of basically the courts are saying just a great expansion of people who are no longer eligible to come out on bond, and a greater amount of people who are now subject to that expedited removal. Okay, so I'm not gonna bore you with case names or anything like that, but this has been a huge part of what has been going on this year, that particular litigation. Okay. Then we had the visa and travel restrictions for many countries. We have pretty much a ban on travel, for nationals of 39 countries. Okay, and I'm gonna list all of them, but there are many countries that are impacted. Haiti, Venezuela, Cuba, Iran, there's so many more, okay, many African countries. If you have a question, just Google if that particular country is impacted or not. But if your case is processing abroad, it's just going to be on pause. If your case is processing here, there's going to be no decision. They are accepting applications. They're even conducting interviews, but there's no final adjudication of any decisions for nationals of those countries. Okay, so then we have big changes in the H-1B visa processes. So we now have a ginormous $100,000 fee on employers for applicants that they need to pay. There's also H1 was a lottery for many years now, so they changed that. It's now going to be more like a weighted selection rather than a pure lottery. So they will prefer people that earn more money when they do that lottery. Okay, and once that pool is done, they'll go to like lower. So basically, the more you earn, the higher your chances will be. The less you earn, the less your chances will be. Okay, so those are the big changes to the H1 process. Then we have huge changes to TPS, temporary protective status. Pretty much no more. Just about not every country yet, but many countries. So we still have TPS Ukraine. I believe we still have some TPS, but they're getting rid of a lot of TPS. Okay, countries that had it for many years no longer have TPS, and if you had TPS and you didn't have any other application pending, you really need to speak to an attorney to see what options are out there available for you. Okay, because once you lose TPS, they're going to place you in removal proceedings. Okay, so this is another big change that has been happening. An application is denied, green card is denied, they're going to put you in removal proceedings. 751 is denied, they're going to put you in removal proceedings. And 400 is denied and you're removable. If it's denied for something, you didn't show up to an interview, or, you didn't pay taxes or something, or you traveled longer than that you should have, no, they're not going to put you in removal proceedings. But if you have an underlying criminal conviction and that's the reason for the denial of your case, and that criminal conviction makes you removable, they're going to put you in removal proceedings. Or there was some underlying fraud, right, that they found, they're going to put you in removal proceedings. Okay, so basically much greater enforcement. A denial of the application will lead to a person being placed in removal proceedings. Okay, and then we have another greater enforcement that we're seeing, that some people are being detained at interviews. Okay, now some jurisdictions are better than other jurisdictions, but there have been people detained at their green card interviews. There have been people detained at their biometrics appointments. Okay, it all depends. There have been people detained when they are stopped at an ICE checkpoint. Okay, it doesn't matter that you have a pending case. It doesn't matter that you have an asylum application that is pending for years. Green card interviews, the detentions at the green card interviews, you're obviously there because you're eligible for a green card, right? You're married to a U.S. citizen, or something like no underlying criminal thing. So that has been happening. Okay, I can't say that it's happening all the time, no, but there have been enough cases where we hear about it. So it's just very smart now to have your application be prepared by an immigration attorney. When you go to that interview, don't go by yourself. Hire an immigration attorney, have somebody there. They're not magicians, but sometimes we are able to talk them out of detaining a person. Sometimes they're not. Okay, don't kid yourself, and we shouldn't kid ourselves. Okay, but having an attorney there does give you at least the understanding that somebody's going to be there of fighting on your behalf and provide some sort of authority or sense into ICE when things are happening. Another change that happened, this is actually fairly recent, so biometrics for the last, I don't know how long, but for a long time now, they have been recapturing biometrics. So if you submit an application for the first time ever, you've never submitted before, yes, you will have to go to biometrics. But then if you resubmit another application and another application, they would waive that. They would recapture those previously taken biometrics. Not anymore. Now they're saying if your biometrics are older than 3 years, you will have to show up to another biometrics appointment, and they will recapture biometrics. Okay. Asylum. So asylum law. Many changes there. So let's talk about affirmative asylum. Affirmative asylum is when you apply for asylum to USCIS, to the administrative agency. Okay, so there is a pause on adjudication, final adjudication, yes or no, on all cases. So even if you had an interview, there's not going to be a decision, okay, because they have paused that process for now, no matter what country you're from. Okay, so you can still submit an application. You still have to do it within a year. It has to be a complete application. You have to answer every question on that I-589. Incredibly important now. Okay, there's been a huge law, litigation. Cases have been remitted if it's not a complete application, okay? Every single question on that I-589 has to be answered completely, okay? Have you traveled, for example, have you traveled through any countries while coming to the United States? If you have, which countries did you travel through? Did you have any status there? Did you apply for any status? Why or why not? How long did you stay there? When I say that that answer has to be complete, that answer has to be complete. I traveled to the United States through, Turkey, then Mexico. I was in Turkey for 2 weeks. I did not have any status. Why I did not have any status? Okay, you have to provide an explanation. After Turkey, after the 2 weeks, I went to Mexico. In Mexico, I stayed for 2 months. I did not have any status. Why did you not have any status? Okay, you have to really read the question and then provide a complete answer to that question. And if you don't have enough space and that little, thing that they provide, then you need to, that last page of the form 589 it gives you that extra space. And if you're going to be using more than one sheet, then that's what you're going to be doing. The answers have to be complete, okay? Then on top of those complete answers, you have to provide a statement. If you don't speak English, it has to be certified translated. And then you have to provide initial documents to show your eligibility for asylum. Very important now, okay? So that's administrative asylum. Defensive asylum. To say that it has been difficult is to not say anything at all. It has been very difficult, okay? There have been preterm missions happening in the last, 3, 4, 5, maybe 4 months now. So the preterm missions, what happens is, you get to court and then the government says, Your Honor, we move to pretermit. And it's done for 2 reasons. One, the incompleteness of the application, okay? And there's now case law that says that. And 2, no jurisdiction, basically saying that the United States has an agreement with a third country, whether it's Honduras or Uganda or Ecuador, and we move to pretermit, and this person can go to that country and seek asylum there. Okay, this has been happening left and right. Okay, there's some judges that won't hear any arguments from the attorney at all. Okay, not because your attorney is bad. Okay, this is just because it's happening. Some judges will hear arguments. It really has been judge dependent. It's bad. Okay, but please do understand that you may have your entire case well prepared and submitted, and you may actually have a decent case or very good case, okay, but it could get pretermitted because of the ACA agreement, okay? So there's no pause on decisions in the defensive cases, in defensive asylum. So cases have been granted even after that executive order. It's just been really difficult, okay? It's been very difficult to agree on anything, really, with DHS attorneys. They don't agree to anything. They reserve an appeal on pretty much everything. Don't do this by yourself. I mean, obviously, if you're in immigration court, you need an attorney. If you're doing this administratively, please get yourself an attorney, because it's going to be very difficult to fix it later on, okay? And I'm seeing a lot of cases where, for many years, cases were empty filed, right? And they were bare bones applications. And then, in court, attorneys would update them. No longer the case, okay? Now, it counts, okay? And if your application is bare bones, it's gonna come and haunt you, okay? So prepare differently, okay? Everything you knew from how it was done before, no longer done this way, okay? Read, get yourself an attorney that you trust. Make sure you have answers to the questions. It's not gonna get any easier, I can tell you that much, okay? So that would be a very short recap of 2025 and immigration law. There are other things that happened, but these are the major changes, okay? And I leave you with that. Talk to you soon, everybody. Bye.